Good morning, everyone. We're here today for oral arguments. We're going to begin with three cases, 23-3310, 24-1273, and 24-1289, Federal Trade Commission versus Day Pacer LLC and Margaret Cummings. We're going to begin with oral argument from Mr. Gonsalves.
Good morning, Your Honors. It may please the court, counsel, co-counsel. We are here today to talk about whether or not the corporate defendants violated the telemarketing sales rule. The specific provision at issue was found at 16 CFR 310.4 B.1.3. And that provision says that a telemarketer is prohibited from initiating an outbound telephone call to individuals on the Do Not Call registry who have opted out of receiving telephone calls that induce the purchase of goods or services. The district court ruled that the definition of a telemarketer, or definition of telemarketing, does not require that the sale or the inducement for the sale of the goods or services does not need to be included in the telephone call made by the telemarketer. It is my view that that is error. The court focused on the definition of telemarketing and the definition of a telemarketer in 310.2 GG and 310.2 HH. That provision of the telemarketing sales rule was amended in April of this year, and so in some of the briefing you might see references to FF and GG instead of GG and HH, but it didn't change the definition at all. The definition of a telemarketer, it is a person who, in connection with telemarketing, initiates telephone calls. Telemarketing is a planned program or campaign that involves one or more telephones that induces the purchase of goods or services. But engaging in telemarketing or being a telemarketer is not prohibited by the telemarketing sales rule. There's only two types of telephone calls or two types of telemarketing that is prohibited. That is deceptive telemarketing and abusive telemarketing. The provision that we are focusing on is abusive telemarketing in B.1.3b. And that requires first that you must be a telemarketer, and two, that you initiate an outbound telephone call to an individual whose number is on the Do Not Call list. The definition of an outbound telephone call is a telephone call initiated by a telemarketer that induces the purchase of goods or services. And it seems to me that the plain language and the definition of this outbound telephone call requires that the call made by the telemarketer include the inducement to purchase goods and services. The district court concluded otherwise, and in her conclusion, she didn't cite any authority for that outcome. The district court also concluded that the plan, program, or campaign that is in the definition of telemarketing can be satisfied by the conduct of more than one company, even though they are independent of each other and have no relations with each other. Here, the district court concluded that the plan, program, or campaign was the result of the conduct by the corporate defendants, as well as by the colleges and universities that purchased the consumer data. There's no allegation in the complaint that there is an agency relationship between the defendants and these colleges and universities. There was an allegation of agency between the corporate defendants and these inbound transfer partners, these call centers that was talked about in the case. The district court concluded that the Federal Trade Commission failed to prove that agency relationship, but there wasn't any allegation of an agency relationship with the colleges and universities. The FTC alleged that the corporate defendants provided substantial assistance to these IBT partners, these inbound transfer partners. They did not make a similar allegation with respect to these colleges and universities. They are completely independent of each other. One's a buyer and one's a seller, and nothing more. And I don't believe that the facts support that there is a relationship between these two companies either. One of the pieces of testimony that the FTC may cite to is the testimony of David Cummings. And he said, the goal of the two call center companies was to sell leads. The conversion of those leads into the sale of the educational services was relevant but not essential. It was not an important business metric. In other words, the plan, program, or campaign of the corporate defendants, if there was one, was to collect consumer information and sell that information to the colleges and universities, and that's where their interest ended. What happened to that consumer information afterwards was not part of their plan, program, or campaign. The district court and the FTC say that the telemarketing sales rule is analogous to the Telephone Consumer Protection Act, the TCPA.
What material differences do you see between those? Material to this dispute?
I think that the provisions of telemarketing under the TCPA and the provisions of telemarketing under the TSR are analogous. I don't see material differences. And we cited 7 cases in our brief where telephone calls that did not induce the purchase of goods or services was found not to be telemarketing under the TCPA. The FTC says those cases are not relevant because they're not lead generation cases. The only case they cite for their proposition that the call does not need to include the inducement of the purchase of goods or services is Golan versus Veritas. But that case is easily distinguishable. In that case, the marketing company had 2 phone calls that it was placing to consumers. If the consumer answered the telephone, they received the advertisement, the message that said, please come see our movie. If they didn't answer the telephone, they received a very short voicemail. And that's the voicemail that the plaintiffs in that particular case received. The defendants argued there was no telemarketing on that particular call, and the court concluded, no, but your overall plan between these 2 telephone calls was to induce the purchase of services, in that case, a movie. We cited 2 additional cases in our reply brief, and one of them is about a lead generation company, and that is Pepper versus GBG Capital. And in that case, the lead generation company, this company that was collecting consumer data, was a real estate company. And the court in that case said the collection of consumer data is not telemarketing because it does not include the inducement to purchase goods or services.
Counsel, some of that goes to whether or not you meet the definition of telemarketer. In the proceedings below, were you focused on FTC not showing that Daypacer was a telemarketer, or were you arguing to the district court that if you were a telemarketer, you still weren't a telemarketer making outbound calls?
I think in the proceedings below, we were arguing we were not making the outbound calls as defined under the TSR, that our telephone calls did not include the inducement to purchase goods or services. And we think that that is a necessary element to satisfy to meet the elements of the TSR that we're focused on in 310.4B13. So we think it is error for the court to have concluded that the calls need not include the inducement to purchase goods or services. And we think it is error that the court can link the conduct of 2 independent companies together to satisfy the planned program campaign portion of the definition of telemarketing.
Let's assume we don't agree with you, and so then we do get to the issue of penalties. Can you shift to penalties before you reserve your time for rebuttal?
Yes, I will. Mm-hmm. And if the court disagrees with me, the question then is, was it appropriate to find the corporate defendants and the individual defendants liable? Did they have the knowledge, or the knowledge fairly implied, that the conduct at issue violated the telemarketing sales rule. The corporate defendants and the individual defendants testified in declarations that they understood the requirement to be that their telephone calls had to include the inducement to purchase goods or services. The FTC and the district court point to other evidence. They say some of your contracts included references to the TCPA and the TSR, so you must have known of its existence. You received complaints from consumers. There's about 20 complaints from consumers, and there was even a couple of lawsuits that all focused on the Telephone Consumer Protection Act. So you must have known that the TCPA and the TSR existed. But the requirement is more than that. The requirement is that you not only knew of the existence of the rule, you have to know that your conduct, or that the knowledge is fairly implied, that the conduct at issue actually violates the telemarketing sales rules. Our declaration said we did not understand that it did so because our calls didn't include the inducement to purchase goods and services, and therefore we are outside of the realm of the telemarketing sales rule.
Do you want to save some time for rebuttal?
I do. Thank you very much.
Thank you, Mr. Gonzalez. We'll now move for oral argument from Mr. Douglas.
Good morning, Your Honors. May it please the court. My name is Richard Douglas. I'm here on behalf of Margaret Cumming, personal representative of the estate of David Cumming, planning today to discuss the substitution ruling and a little bit about the civil penalties if I have time. Regarding the substitution ruling, for that I'm going to look to this court's Smith test, which is a three-factor test that everyone agrees applies. The district court below found that one factor favored abatement, whereas two of them factored not abatement and survival. We think all three factors lean penal, and so it should be reversed.
It strikes me that the third factor is really the proportionality issue where there's a big debate here. Is there any aspect in Smith, and I'm specifically referencing the key paragraph where the three factors are listed? The third factor is listed where the authorized recovery is wholly disproportionate to the harm suffered.
Correct.
Cites Murphy. You go to Murphy, the formulation is slightly different in Murphy. It reverses the wording. You go back further into this, the old Supreme Court cases, the wording is even different there. We're tracing this chain of the test, right, all the way back. Is there any aspect of changes in the wording that you think impacts that third element?
On factor three?
Yes.
I mean, I think that the key word there is the authorized recovery. I think that is the key language that was stated in Smith. And when you look at what an authorized recovery is, there really is only one number as far as we can tell, and that is the number that the statute says is the authorized amount you could seek. And that's where we think the district court erred, was by departing from that number and relying on Parchman, saying that because there was discretion, it could look at only what the FTC was seeking. I don't believe Parchman said that. It was only saying that, actually in Parchman, it did use the authorized recovery. It used the $500 and $1,500 per call and found that that was disproportionate. I would submit that the $40,000 here that's authorized is even more disproportionate. So that's the language, I think, on factor three that was essential to the test that we're arguing today. There was also a change in factor one that the Smith court made from the Murphy court, which was to change the language from the statute to the action. And then saying that for factor one, you look to whether the purpose of the action is to redress individual wrongs or wrongs to the public as opposed to the statute. And what we saw here is that the court looked at the statute and it analogized the TSR to the TCPA and other consumer protection statutes. And based on that overarching view, ruled factor one was leaned in favor of remediality.
Other than Smith, Murphy, Huntington, we looked, is there any other case law that, Parchman, obviously, any other cases that we should be aware of that speak to this determination?
So I think that the old cases that Your Honor was referencing, for example, the Schreiber case, which was cited by the FTC, and we amplified that in our reply, it sets forth this early notion that you're focused on the action. You can't necessarily say it's a Smith factor 1, 2, 3 test because it predates Smith by 100 years, but it definitely focuses on more than just the overall purpose of the statute. So while overall purpose of the statute is something you would look at, and in some cases it might be determinative on factor one. Where it's not, where you have a mixed-use statute, you need to look at something more, and I think the Smith court said exactly what that should be, and that's very consistent with Schreiber. The only other factor on the Smith test is factor two, which everyone agrees goes in our favor, so I will move on past that. Unless the court has other questions on the substitution point, I'll move on to the civil penalties. And there I'd like to make 2 points regarding the civil penalties. The first one is that the court applied joint and several liability to the civil penalties, and in that way made everybody liable for everyone else's conduct. And we believe that that is not supported by any authority that was cited by the FTC or the district court, and runs contrary to the notion that is in the statute itself that these determinations have to be done individually. So for that reason, we believe applying joint and several is inconsistent with the statute, and so was an error, an abuse of discretion on that point. And then the last point I want to make on the civil penalty factors before my time expires is the civil penalty factors were not actually used. This court summary judgment opinion at A58 in our appendix lists them and then goes through what the FTC was seeking, but then didn't actually go back and apply them in that opinion. Instead, the court asked for more briefing. And then when we gave the court the additional briefing, the court at A64 of our appendix said, we've already applied the penalty factors in our summary judgment opinion. So they actually...
Well, she also credits the FTC's evaluation of the factors. Why shouldn't we look at that, plus what she said in the summary judgment order, plus what she said elsewhere in this, protracted manner of really looking at the issue, getting input from the parties, and why can't we look at the total picture and see her as analyzing all of those factors?
Well, I think you can look at the total picture and seeing that she had agreed generally that the FTC had made positions on those factors, but then she didn't analyze the responses that we put in at her request in the civil penalties ruling, instead saying that they had already been done. So from our perspective, the factors were listed, but then not actually used, and what you end up with is a penalty that doesn't line up. It doesn't fit the factors. Most obviously, ability to pay. No one can pay this penalty. It's twice what the estate can pay. It's over 30 times what Mr. Ian Fitzgerald could pay. So by listing the factors and then not actually taking the time to do the analysis, at least that is my view, that's an abuse of discretion that needs to be vacated. And
Thank you, Mr. Douglas. You'll reserve the remainder of your time.
Thank you.
We'll now move Mr. Hagedis to you.
Good morning, Your Honors. Mark Hagedis for the Federal Trade Commission. May it please the court. The district court found that DayPacer was responsible for at least 4.1 million calls to consumers whose numbers were on the Do Not Call registry. DayPacer used those calls to generate leads it sold to telemarketing for telemarketing purposes, earning nearly $28.7 million over 5 years. David Cumming and the Fitzgeralds owned and managed DayPacer, and they benefited through their ownership of companies that supported its operations. We believe the district court should be affirmed for 4 reasons. First, undisputed facts establish that DayPacer's calls to the numbers on the Do Not Call registry violated the TSR. Second and third, the district court did not abuse its discretion in holding the individual defendants liable for civil penalties and enjoining DayPacer and the Fitzgeralds from telemarketing. And fourth, the district court properly substituted as a defendant the Cumming estate. At the outset, Your Honor, I'd like to address some of the points that counsel for the other side raised. The first one regarded this case, Pepper v. GBG Capital, and it's clear from that case that that telemarketing or those phone calls involved purchases. The courts there rested their decisions on the fact that the calls involved purchases and not sales of goods and services. With respect to the question of authorized recovery, to say that the FTC Act and the civil penalty provisions authorize only the maximum civil penalty looks at only half a loaf. The full loaf is the maximum plus the required 5 factors. And the district court here absolutely took into consideration the 5 factors, including by relying upon the FTC's own analysis of those 5 factors.
Where do you see the district court making findings on each of those 45 M1C factors, particularly ability to pay and effect on business?
Yes, Your Honor. So the district court did not go into great detail with respect to its findings on each of the 5 factors. Rather, it made note of the fact that the FTC itself had analyzed those factors. With respect to the ability to pay and the effect on the business in particular, that was the subject of the supplemental briefing. The district court, when it ruled on summary judgment, it concluded that it needed more information as to whether or not to assess civil penalties, the amount of the civil penalties, focused particularly on the information that might have changed from the time of the summary judgment briefing. And there the focus was on ability to pay and the effect on the business. And then when the court ruled following that supplemental briefing, it focused on those factors and rejected the attempt by the estate in particular to relitigate those factors that would not have changed from the summary judgment briefing, and in particular the factor of culpability as well as harm.
What's your response to opposing counsel's point that where the court doesn't acknowledge their responses after she calls for the additional briefing, how do we have any confidence that the court did consider each of those factors?
Your Honor, the court absolutely did acknowledge the responses. The court divided those responses into 2 categories. One, the court rejected the effort to relitigate facts that had been decided and would not have changed between the time of the summary judgment briefing and the ruling on the civil penalties. And specifically, I'm referring to the actual conduct of Mr. Cumming, the actual conduct of the other defendants. That conduct had been established at the summary judgment briefing. The facts that the court took into consideration were facts that could have changed, such as the ability to pay and the effect on the business, as well as the estate's request that the court take into consideration the particulars of the estate. And there, the court concluded, and correctly following this court's precedents, that the estate stepped into the shoes of Mr. Cumming. And so the state had to take the factual record as it found it and could not relitigate, as the court observed in its prior decision with respect to substitution and whether or not a state steps into the shoes of the substituted party. It would make a mess of litigation if the substituted party could go back and relitigate issues already decided. Another point I'd like to address, Your Honors, with respect to what my esteemed counsel on the other side talked about was this issue of whether or not one focuses on the action or whether one focuses on the statute and the purposes. And we believe that whether you focus on the purpose of the action or the purpose of the statute, the first factor under Smith points in the direction of substitution, in that the civil penalties here, and the court found below that the civil penalties here work to redress harm to individuals. And that comes from the recognition that the harm from these unwanted phone calls is felt by individuals. It interrupts their meals, it distracts them. This court in the Patriotic Veterans case recognized that as well, that individuals are harmed.
This is the problem, though, with sometimes relying on congressional findings, because frankly, it could cut either way, right? It could be for the public, it could be for the individual. Parchment doesn't help us that much. I'm just not sure how much work that first purpose factor can do here. Your response?
Yes, Your Honor. And I think the court in the Smith decision recognized that that first factor can have aspects that point towards remedying harms to the public, can have other aspects that point to remedying harms to individuals. And I think there's an important analogy between the Smith case and this case. One of the facts that the court in Smith found relevant was that the disclosures there under the Truth in Lending Act helped to empower consumers so that they could make their own decisions about the terms and conditions of credit. Similarly here, the Do Not Call registry empowers consumers to make their own decisions about whether or not they want to receive these kinds of phone calls. And so in that respect, the focus on harms to individuals is very similar between Smith in this case.
And let me get back to the TSR for a second. The definition of telemarketer includes plan, program, or campaign. We don't see that in the definition of outbound call. There's no dispute, I think, that the particular outbound calls that Daypacer made didn't, in and of themselves, without additional planned calls down the road, induce the sale or purchase of any goods or services. How are you reading the definition of outbound call to include Daypacer's activities?
Your Honor, I think it requires some artifice to say that the calls that Daypacer made were not the first step in a sale or a campaign to sell. To sell, you have to make the opening sell, though. That's exactly what Daypacer was doing here. It was calling consumers whose names were on the Do Not Call registry and asking them questions to gauge their interest in in these education products. It's as though a consumer walks into, or actually, I should think about it separately. Someone comes up to you on the street and starts asking you questions about your interests, and then with the goal of eventually perhaps selling you a product. The sale pitch starts with that initial contact. So we have other examples, for example, in where this FTC deems as telemarketing, parties that engage in this kind of lead generation without necessarily having any particular product in mind. They simply then post those leads out for sale to companies that want to call those consumers, but there's no particular requirement that it be tied to the sale of a particular product.
So ground that for me, if you will, in the definition of the outbound telephone call being initiated by a telemarketer to induce the purchase of goods or services.
Yes, Your Honor. I mean, the outbound telephone call here was part of this plan to identify consumers who might be interested in these education products. As I said, to try to separate out that initial phone call, that opening bid, that opening pitch from what was being sold, and in this case, Daypacer was very clear that it was engaged in this lead generation in order to, they had contracts with these education companies.
Then why wouldn't the FTC have put the same language in the definition of outbound call that it did in the definition of telemarketer and include in the definition of outbound call a plan or a program to induce the sale or purchase?
Your Honor, I don't have an answer to that question. I would be happy to go back and obtain that information from my colleagues who were responsible for the TSR and provide supplemental briefing on that point, but I don't have an answer.
Do you agree that it creates some ambiguity?
Yes, Your Honor. Okay.
Well, while we're on the subject of the TSR, does the record show that anybody other than Cumming actually looked at it? And if not, how is it one can say for the other defendants they have knowledge or fairly implied knowledge if they were told by Cumming that the TSR did not apply to Daypacer's activities?
Your Honor, the knowledge is satisfied here in a number of respects. Number one, we have to look at the fact that we're talking about the owners, the managing members of these companies. Mr. Raymond Fitzgerald held that position, Mr. Cumming held that position. From the outset, EduTrack, which later became DayPacer, entered into contracts with the education companies. And in those contracts, and these are the education companies that actually were pitching, making the calls to, or trying to sell the education products, those contracts required that DayPacer or EduTrack comply with the TSR. It specifically identified the TSR. So going back to the period of, say, 2014, the contracts that EduTrack entered into specifically required compliance with the TSR. At the same time, EduTrack was entering into contracts with its IBT partners, where it was requiring its IBT partners to also comply with the TSR. So this idea that somehow the TSR was out there and DayPacer and its owners and its managers didn't think it applied to it is contradicted by the actual evidentiary record, which shows that DayPacer itself, EduTrack itself, was undertaking obligations to comply with the TSR. In addition, the district court found that the defendants in their affidavit said, yes, we understood the TCPA to apply to us, but we didn't think the TSR applied to us. And the district court found that that was not objectively reasonable given the similarities between the TCPA and the TSR. The two both rely upon the Do Not Call registry. They impose similar requirements. In fact, Congress required that the TCPA align with the TSR.
Is the answer to my initial question, does the record show that anyone other than Cumming looked at it? Is that answer no?
Your Honor, there's no evidence in the record that Mr. Fitzgerald, for example, opened up the rule book and looked at the TSR. However, Mr. Cumming sent an email to Raymond and Ian Fitzgerald saying, you need to take a look at this. Mr. Cumming was aware. He tried to make his partners aware of the requirements of the TSR, and certainly the record supports that. The actual documentary record that provides support for the district court's conclusions that here there wasn't any dispute about the partners, about Mr. Cummings and about the Fitzgerald's knowledge about the TSR. One other issue with respect to the Schreiber case that counsel on the other side mentioned is the fact that if you look at that Schreiber case, the court focuses on what they call the penal statute, an action under a penal statute. And I think that lends support to this idea that you really can't separate out a purpose of an action from a purpose of a statute. These are going to be interrelated ideas. In order to understand the purpose of an action, it necessarily requires taking a look at the statute.
That may be why the third factor, the authorized, what authorized means, becomes so important for that analysis, right?
I agree, Your Honor. And in this case, the authorized factor, points towards a remedial, or points to allowing substitution in the following way. While the FTC Act has maximums with respect to civil penalties, it also requires an examination of these 5 factors. And here, the district court adopted a civil penalty that is far below the maximums. So the district court used its discretion to set a civil penalty that reflects the facts of the case. And so one of the things that the Sixth Circuit recognized in the Parchman decision is that where a district court is exercising its discretion in this way, that suggests that it is serving a remedial purpose, that it is attempting to address the harm found in the by the court based upon the facts of the case.
But because it has the ability to lower the award below the maximum, that doesn't mean it always will, correct?
That is correct, Your Honor. Here, however, the award is very much below the maximum. And when you take a look at the award on a per-call basis, $6.88, it shows that it is not at all disproportionate to the harms that are caused by these phone calls. Again, pointing to the Parchment decision, there the Sixth Circuit suggests that $500 was not disproportionate, $500 per call. Here we're talking about a phone call, or excuse me, a civil penalty set at $6.88 per phone call, so far below $500. And while the other side does talk about the fact that there's not concrete or numbers, quantifications of the harm, it is well recognized by courts that these kinds of harms are hard to quantify. But it is undeniable that there is harm here. There is harm from the fact of being interrupted.
But can we talk about some of the specifics? Do you agree that the district court found only liability in terms of, I want to look at the transfer calls, only from Blue Water, it looks like?
Yes, Your Honor.
Should we be concerned about that?
No, Your Honor. So the Blue Water call transfers provided the basis for finding that the defendants here violated the substantial assistance provisions of the telemarketing sales rule. And with respect to determining the per call penalty, the district court looked at the calls that were transferred, and that could be documented as having been transferred from IBT partners to Daypacer, and it worked out to be about nearly 500,000 calls. That was added to the calls that Daypacer made itself to come up with the 4.1 million calls that served as the denominator to determine the per call penalty. But with respect to the statements in the district court decision regarding the not finding of liability with respect to a bunch of other calls made by the IBT partners, that is referring to the fact that the IBT partners were responsible for nearly 40 million calls that were the result of the contracts that Daypacer entered into with the IBT partners. The district court, neither its injunction nor the civil penalty award accounted for those in its determinations. And so when the court says it did not, or the FTC did not seek to hold Daypacer liable, it is talking about not the Blue Water calls, but the nearly 40 million other calls that the IBT partners were making to consumers, some of whose names were on the Do Not Call registry, and for whom Daypacer did not have, there was no indication of consent.
Thank you, Mr. Hagedis.
Thank you, Your Honors.
Mr. Gonzalez, we'll move back to you, and we're going to give you 2 minutes for a vote.
Thank you, Your Honor. I'd like to address the individual defendant's culpability that was talked about a little bit. In order for them to be found individually liable and subject to the civil penalty, they must have had to participate directly in the deceptive acts or practices, or had the authority to control them. I think here there is at least a genuine dispute as to whether or not, genuine dispute as to the material facts. Counsel referenced that Raymond Fitzgerald was the managing member of the organization. That is true. He was a 50% owner in a family trust. That family trust owned a portion of the businesses. Typically, investors aren't liable for the conduct of a corporation. The evidence is that that family trust owned a real estate company, and that real estate company leased its property to the companies. Typically, real estate realtors or landlords are not liable for the conduct of their tenants. Ian Fitzgerald at EduTrek, for the first half of the period at issue, he was the Director of Human Resources. That is not a position that I would think would give rise to the authority to control the conduct that is issue here.
Is this June 2016 that he makes the change?
June 2016, he makes the change, but prior to that, he was not in a position that one would think would give him the authority to control the operations of the business. Did he send an email saying, I'm involved in the business? Yes, he did. But I think what that presents is a genuine issue of materials, facts, and such that summary judgment should have been awarded on that basis alone. And with that, I rest here.
Thank you very much, Mr. Gonsalves.
Thank you very much.
Mr. Douglas will move to you, 2 minutes for rebuttal.
Thank you, Your Honor. I just want to address a couple of points. One thing that Your Honor had mentioned was, is there a distinction between the TSR and the TCPA? And I think that was a question. For purposes that Mr. Gonzalez was talking about, I think the answer is no. For purposes of survival, I think the answer is yes. And that is the remedial statutes that were found in Parchment and other cases to be overall remedial, they all had these private attorney general provisions. In fact, those are usually the provisions that were of concern, were these private attorney general provisions. But all the courts that looked at those said, this actually promotes a remedial purpose to this because it causes private individuals to bring actions for their own claims. The TSR is the opposite of that. It has a $50,000 floor on what your damages can be, which substantially limits the ability of private individuals to go ahead and bring their own claims. So for that reason, I think on the issue of survival, it is decidedly more penal overall, the TSR is, than the TCPA or the TILA. So I want to address that. One other point was made is there's a stand in the shoes argument that's being made that changing things or allowing briefing would mess up the proceeding. Nothing was decided on summary judgment until after substitution. Substitution was decided before it, immediately before it in the order. All of these decisions were made after substitution, and so we're not talking about messing up the proceedings that had gone beyond prior. I'd also like to mention that there were some mentions of the 2014 contracts. The record shows that Mr. Cummings said he was not involved in those contracts, and there's no evidence as to when he ever saw them, if he did. That's just a missing piece of the record. So the best evidence that the district court could find was that Mr. Cummings knew in about 2016. So for that reason, the 2014 and 2015 time period that we're using for for civil penalties and for wrongfulness, I think should be cut back to 2016. Thank you very much.
Thank you, counsel for appellant. Thank you, counsel for appellee. The case will be taken under advisement. We're now going to move to case 24-1347, Rao versus J.P. Morgan Chase Bank and Kraus. We'll begin with the argument from the appellant, Mr. Steigman.
Mr. Steigman.
Mr. Steigman, thank you.
Good morning, Your Honor. Michael Steigman for Dr. Rao. Good morning, counsel. We are here today on the appeal of 2 counts that were dismissed. A defamation count where the defendant, Chase Bank, accused Dr. Rao of using her power of attorney to establish a POD designation, a payable on death designation, on her mother's accounts without her mother's knowledge, just using her own POA and defrauding her mother. You know, you're not allowed to use your power of attorney to take over your mother's accounts upon her death. We're also here on the appeal of a Consumer Fraud Act claim where there's a statute saying a entity, a data collector, can't release personal identity information unless it's authorized by the owner of that information. In this case, that was Dr. Rao. And the Illinois statute on payable on death designation specifically states that upon the mother's death, that POD account belonged solely to Dr. Rao. And if we are going to have protections for such data, which the Consumer Fraud Act wants, you can't disclose such personal information without either legal process, a subpoena, or getting the permission of Dr. Rao. And neither one of those was done here, and that's why Chase violated the statute. Getting started on the defamation claim, the trial court had 3 reasons it found to grant the dismissal on summary judgment. The first one was whether the statement had been made at all. We supplied the defendant Krause's own affidavit, and paragraphs 11 and 15 of Krause's own affidavit. He specifically states he confirmed to the third party, to the estate administrator, that Dr. Rao used signature cards to establish the POD in her favor by the use of the power of attorney. So we have his own affidavit stating what we claim is defamatory language.
Speaking of affidavits, in your reply brief, you referred to 2 Krause
Yes.
affidavits, one from 2023. What are you referring to there? We tried to follow it. Are you referring to Krause's interrogatories?
No, Your
That's
Honor.
the
So
second.
what the defendants did here is in their summary judgment motion, they attached a new Krause affidavit dated 2023, which tried to explain away what Krause's statements in the first 2020 affidavit. And the trial court allowed Krause, allowed the defamation defendant to explain away what he understood his statements in 2020 to mean. And that is not allowed under Illinois law. Under Giant Screen and Tuit, it's the reasonable recipient, the reasonable reader, determines what a statement means on its face. And what Krause himself understood 3 years later has no bearing on whether the statement was defamatory. He is not entitled to any additional weight instead of plaintiff or Mr. Singler or the estate. It's the reasonable reader. It's an objective standard. So it was completely improper for the court to put extra weight on a defamation defendant's subsequent affidavit trying to explain away statements he made earlier. It's not evidence at all.
So back to your outline, when
Yes.
you were referring to his affidavit, you're referring to the original.
Yes, I am referring to the original affidavit. Paragraphs 11 and 15 of his original affidavit are the statements we have said are defamatory.
And just because inquiring minds want to know, why not take the deposition?
We could have, Your Honor, and we have gone ahead and just used the affidavit here because, you know, we had the statements in the affidavit signed by the defendant himself. We also have the filing by the estate using, the affidavit to explain away why he made the filing in the first place, accusing Dr. Rao of fraud in open court and elder abuse.
But assuming that the affidavit establishes all of that, how does it establish recklessness?
Well, we have our own grounds for recklessness, Your Honor. We have submitted Dr. Rao's affidavit, and she talked to several Chase employees, and it's undisputed here that these Chase employees said, first of all, Chase's own records would have shown that the POD designation was made in 2012 and not 2013. It's also undisputed that Chase's own procedures and policies would have prohibited Dr. Rao from using her power of attorney to make a self-serving request on her behalf. Those are both undisputed. It's also undisputed that Dr. Rao, the signature card is not how a POD designation is made.
But without a deposition, how are we getting into Krause's state of mind and saying he's reckless? Even if we agree he didn't follow internal policies, how do you go from there to recklessness?
Certainly, Your Honor. Under Giant Screw, the defendants have to do a reasonable investigation of the circumstances before to avoid abuse of the qualified privilege. And in this matter, specifically, Kulik involved the Illinois Supreme Court case that found abuse of the qualified privilege on a summary judgment motion. The defendant got an opinion only from its medical department, but it should have also consulted its legal department before saying this chiropractor had performed improperly under Illinois law and we can't pay the insurance claim. So, and Giant Screen also, the defendant itself, the entity, it was a forged document, and the defendant should have, document A was forged, document B among the same documents. There was certainly a question, if somebody forges document A, they might have also forged document B. You have to do a reasonable investigation. And the case cited by the trial court as well, Judge Lee, originally saying, we've got to the Boyd case. If there are records that the defendant has and could be investigated, it hasn't conducted a proper investigation. Overall, especially I think Kulik is the best example of this. If an institution has knowledge, easily obtained knowledge, that if it investigates its own records, if it contacts the right people, it will come up with the truth and not falsely accuse a third party of fraud, falsely accuse Dr. Rao of defrauding her mother. The institution has to conduct that reasonable investigation. It's a question of fact. If one part of Chase knew that Dr. Rao could never have done this legally, one part had records that showed she couldn't do it, and perhaps the most direct answer is that Donna Glavin, the Chase employee that we cite in our affidavit, who Dr. Rao talked to, she appears on the signature card that the defendant, Krauss, relied on to conclude that Dr. Rao committed fraud. All he had to do was call Donna Glavin, because that was her job to make the payable on death designations. And that's like the Kulik case. If the medical department is unsure of the legal ramifications of an Illinois statute on whether a chiropractor is properly practicing under Illinois law, the medical department has to contact the legal department. It can't come out with a potentially defamatory statement without consulting everybody else in the institution, particularly the people who are assigned to know it. And if defendant Krauss had never done POD designations, didn't know where the electronics record were, didn't know how POD designations are even made, didn't know it was against Chase policy, that of course someone with the power of attorney can't make a self-serving POD designation in her favor, he was obligated to contact somebody else at Chase who did know all these things, especially Donna Glavin, who was Dr. Rao's banker and who appeared on the Chase signature cards making that payable on death designation. Your Honors, I'd like to quickly cover the qualified privilege claim we have here too. As I said before, I'm sorry, the Consumer Fraud Act claim. We have also alleged a Consumer Fraud Act claim here. This account belonged to Dr. Rao upon the death. And before you can release personal information under the Illinois statute, you need authorization. And just because it once belonged to the decedent, you still need subpoena power. It's as if a dispute between a home buyer and a home seller, the home seller just shows up at the house that's no longer his with his inspector and busts in and goes to the basement to inspect it because there's a dispute there, because the asset once belonged to him. That's not how Illinois law works. Once the asset is with Dr. Rao and has never been with the estate, the bank had an obligation to either respond pursuant to a legitimate subpoena or protect Dr. Rao's personal identity information. That's why we have this statute. That's why we have broad protections under the Consumer Fraud Act. this account never belonged to the estate. The estate can ask the bank. The bank could have said, yeah, records show that this POD designation was properly made, but it couldn't just willy-nilly release her personal identity information without a subpoena for accounts that never belonged to the estate.
Would you like to reserve the remainder of your time?
Yes, I will. Thank you.
Thank you very much, Mr. Stigman. Mr. Shirker, we'll move to you.
May it please the court, Elliot Shirker on behalf of JP Morgan Chase. What this record shows is a long and contentious probate battle in state court, in which Dr. Rao was removed as the administrator of her mother's estate, replaced by Midland Trust. Dr. Rao's action against Chase, which is based solely on Chase's compliance with Midland's requests for information on her mother's accounts pursuant to the directives of the state probate court, is we submit the collateral damage from that battle. And the district court correctly ruled that Chase should not be dragged into that probate dispute. We have three independent bases for summary judgment on the defamation per se claim. First, that there is no evidence that the purported defamatory statement was ever made by the Chase banker Kiefer Krause to Midland Trust lawyer Mark Singler. Secondly, any statement by Krause to Singler that led Midland to act as it did in the probate court was at best for Dr. Rao an innocent construction of bank records by Mr. Krause.
Why would they have alleged fraud if it was innocent?
I'm sorry, they're not alleging, they're alleging consumer fraud, but they're not alleging common law fraud against the
No,
bank.
but why would they have alleged that there was the problem that Mr. Stigman has indicated if it was an innocent construction?
I don't know, Your Honor. The bank records say what the bank records say. There's no mystery document here. There's no independent knowledge on behalf of Mr. Krause. He looked at the same documents, for that matter, that Ms. Galvin looked at and that are listed in Dr. Rao's affidavit. What happened was Mr. Singler came to Mr. Krause and said, we need to find out what the status of these accounts is. Who was the POD beneficiary? And the record shows that Singler did that because the probate court had asked Dr. Rao for those records, and she hadn't produced them. There were a couple of screenshots that were redacted. So the state administrator, who is a customer of Chase, came to Mr. Krause to find out. Mr. Krause looked at the 2013 signature cards for the account and gave those cards to Mr. Singler, and understood from those cards that Dr. Rao was the POD beneficiary. Now, the word established got bandied about a lot in the district court. It's not apparently a big issue here today. But Mr. Krause testified, and by the way, there's no second affidavit. There were interrogatory responses, sworn interrogatory responses in the district court. There's the affidavit that was filed in the state court, and there are sworn interrogatory responses, and that's the extent of Mr. Krause's statements. The affidavit states, I looked at the 2013 cards, that's paragraph 9 and paragraph 15 of the affidavit that was submitted in state court by Midland at the end of this entire process, I'd note, because that affidavit also includes Mr. Krause's discovery in his after his third conversation with Mr. Singler that in fact the POD beneficiary designation had been made in 2012. So the whole story was presented to the state probate court. Leaving that aside for a moment, Mr. Krause, in paragraphs 9 and 15 of that affidavit, states that I told him that the 2013 card established the POD beneficiary. In the complaint, that's called the POD statement. That is the sole basis for the defamation per se claim. What Mr. Krause said in his sworn interrogatory responses was, I used the word established to mean it shows that it happened.
Why
word.
Would he continue on to say, why would he add that the designations were established with the use of the power of attorney and by Dr. Rao as the agent of the power of attorney? In other words, what you're saying would make sense if he stopped right where you say he stopped, but he didn't stop there.
Yes, Your Honor. If you look at the card, it has both POD beneficiary and power of attorney. And what Krause said, very much the same as Ms. Galvin said, was that I told Singler it was very unlikely that a POA was ever used to establish a POD. That was his sworn testimony. What the paragraph 9 says, somewhat inartfully, I will concede, but what paragraph 9 says is that there was a POD beneficiary, it's with the power of attorney, they're on the same signature card. The signature card,
No, with the use.
with the use, that's
With
correct.
the use, not with, as in they're on the paper together innocently and unconnected, but with the use of.
And what he
That's a different
testified
meaning.
was, what I meant by that, and what I told Singler was, not that Dr. Rao had done that. He could not conclude from the card that Dr. Rao had done that. That's his sworn interrogatory response. And in paragraph 15, he says pretty much the same thing. So what happened was then, as the uncontradicted evidence shows, Singler went ahead and filed something in probate court. And that's the basis for Dr. Rao's complaint about the use of that first statement. Singler then went, what happened immediately thereafter was, Dr. Rao's counsel sent an email to Singler saying, Chase never told you that. Chase never said it happened on the same date. You're wrong. And Singler then went back to Mr. Krause and said, look at 2012. Look at 2009 when the account was established. Krause looked at 2009 cards and there was no POD beneficiary. That's when the account was created. There was no POD beneficiary at that time on those cards. So he told Singler that. And then Singler came back a third time and said, wait a minute, look at the 2012 cards. And sure enough, the 2012 cards show the power of attorney was conferred by Dr. Rao's mother in 2012. And all the documents in the record bear that out. So we don't have any paper indication whatsoever. And remember, Singler had the papers in his hand that shows the POA was used to create the POD. And Singler says, I didn't say that, and I didn't mean that, and it would be highly unlikely. That's the unrefuted record before the court on the defamation per se. The second reason that the district court granted summary judgment was that even if that's not so, Your Honor, even if Krause was wrong, it was at worst an innocent construction of the documents, which were, as I said, handed to Singler. It was at worst, there was no showing whatsoever that, and no evidence whatsoever, and as the courts noted, there's no deposition of Krause. There's only his sworn interrogatory responses that we submitted on summary judgment. There's no indication whatsoever that he made the statements that he made with any untoward intent, much less reckless intent. He was the private banker for Midland. Midland came and asked him a question. He looked at the documents. Can we look back in hindsight and say he should have dug through the records more? He should have done this. My opposing counsel suggested all sorts of things that Krause could have done. None of that shows recklessness. At worst, it shows negligence and does not defeat innocent construction. And the final reason, which we didn't hear a lot about this morning, the final reason the court granted summary judgment was the qualified privilege. The plaintiff conceded the qualified privilege applied to Chase's communications with its own customer, Midland. And the qualified privilege under Illinois law requires willful intent or reckless disregard for there to be liability when there's qualified privilege. For much the same reason that I've talked about innocent construction. There's no showing whatsoever that Krause acted with reckless disregard. As the district court ruled, at worst, this was a mistaken construction, and the attorney for Midland took it and ran with it by running to the state probate court on that first statement and making an accusation against Dr. Rao. We never made any untoward accusation against Dr. Rao. That was done by Midland. Of course, Midland was protected by the litigation privilege, and Dr. Rao then turned and sued us for Mr. Krause's statement, which, even if mistaken, There's no evidence in this record whatsoever that it was made with reckless disregard, and the sworn interrogatory responses by Mr. Kraus are that there was no such intent. He looked at the document, that's what he thought. He says in paragraph 15 of the original affidavit, he says, I believed that there was a POD and I believed that there was a POA. That's the antithesis of evil intent. Turning briefly to the claim under the state law, the only issue for the court on that claim, which is about 1.25 pages of the opening brief, the only issue is whether, in answering questions from its own customer, which was the estate administrator of Dr. Rao's mother's estate, and was acting under the directives of the state probate court, Chase could have in any way violated its responsibility as a data collector. No, there's no case cited in the briefing from the other side. There's no case we could find in Illinois law that would authorize such a bizarre result. When a bank communicates with its own customer, which was standing in Dr. Rao's mother's shoes as the administrator of the estate, and provides unquestionable documentary information, it cannot possibly be acting in violation of a statute that prohibits data collectors from willy-nilly exposing their customers' data. Thank you.
Thank you, counsel. Mr. Stigman, we'll move back to you for rebuttal argument. Just to begin, Mr. Stigman, how large of an estate are we talking about?
It was in the millions, Your Honor. Thank you, Your Honor. I want to follow up again with your points on the affidavit. And counsel accidentally said the truth here, that what Kraus said was that Dr. Rao conferred the POD designation. It wasn't just proven. He didn't tell Midland, he didn't tell the estate that it was proven. Instead, he said it was established, it was set up by Dr. Rao, which was fraudulent. And I'd encourage the court to also look at paragraph 12 of the affidavit, which says, quote, Dr. Rao wrote back that she claimed the account was not established in 2013, but was established in 2009. And this is in Kraus's own affidavit, paragraph 12. So taking the context of that affidavit, as is required, as this court did in Giant Screen, in that own affidavit, it's using established to mean set up, not to mean proven. Because if Dr. Rao, she's saying it's not about it was proven in 2013. She's saying it was established in 2009. It was not established in 2013. If all we were concerned about is whether there was any designation at all prior to death, if this was just a titling matter, that sentence doesn't make any sense. All we would want to know is, yeah, in 2013, there was a POD titling before death, end of story. There wouldn't even be any reason to look back at 2009 unless the critical issue was when and how the POD designation was established. And Your Honor is exactly right. The affidavit says again and again that it was established, it was set up by Dr. Rao in 2013 using her power of attorney, and that was fraudulent conduct, which the estate subsequently accused Dr. Rao of in court using what it learned from Kraus, what it learned from Chase, and that's why it attached that Chase affidavit to its subsequent explanation. Wow, we don't want to get sanctioned. This is Chase's fault for giving us the false information. And that's why they got the affidavit from Kraus. The court had the correct understanding of the innocent construction rule, and counsel actually made the mistake of reading it properly. Chase accused Dr. Rao of conferring it, establishing it, setting it up, and that was improper. Lastly, Your Honor, I want to briefly address that the district court didn't even consider the affidavit evidence we applied of the improper investigation because it made an improper hearsay ruling. It barred our affidavit statements of the Owen Chase employees. It's undisputed, or counsel has not disputed, that we're allowed to use that evidence against Chase. We've cited the courts. Under that affidavit evidence, Chase failed to look at its own records. Chase should have known that this was improper under its own procedures. Chase should have called Glavin, who knew the POD designation procedure and how this all worked. It conducted an improper investigation, and under Giant Screen and Kuick, summary judgment should have been denied here.
Thank you, counsel. Thank you, counsel. The case was taken under advisement. The court's going to take a brief recess. We're back from a break. We're going to continue now with Appeal 23-1722, Tyree Neal versus United States. Ms. Schnorr, we'll begin with you.
Good morning, Your Honors. May it please the Court, Mary Schnorr for Petitioner Appellant Tyree Neal Jr. Mr. Neal pleaded guilty and was sentenced to a decade longer than the statutory maximum because of his counsel's deficient performance. Specifically, Mr. Neal's plea counsel, sentencing counsel, and appellate counsel all failed to do the basic legal work necessary to recognize that Mr. Neal had a strong argument that his prior state conviction could not count as a felony drug offense under the categorical approach. That necessary work was simply to read the statutes, including the relevant statutory definitions. If counsel had done so, it would have been obvious that the state statute was broader.
Ms. Schnorr, is there a distinction here between Coleman and this case? Because in Coleman, there had to be a remand for consideration of the argument versus here, we know Ms. Christensen did consider the argument.
So, starting with the last thing you said, Your Honor, Ms. Christensen did not, in fact, consider the argument that the court in Coleman said that she was required to consider, which is specifically looking at the definitions and seeing that the state definition of cocaine was broader than the federal definition of cocaine. Now, it's true.
But she considered the categorical approach.
Yes, she considered whether there would be a categorical approach argument here, but she concluded that no argument was available at all because she did not take the step of reading the definition provisions.
Is there a distinction, though, between Coleman where that had not been done and here we know at least the categorical approach had been considered?
The categorical approach had been considered at a high level of generality, but again, the precise argument that the court said in Coleman that minimally competent counsel would have considered, which is specifically the isomer mismatch argument, that was not considered. And it's clear from the record in the evidentiary hearing that counsel did not consider that argument because of what she described as a misstep, which is that she simply did not look at the definition.
So does this turn on level of generality?
So I believe in Coleman, the court said specifically it was that argument about the mismatch between the isomers that minimally competent counsel would have recognized. And it's clear here that counsel did not recognize that.
We've got to look, though, at what Ms. Christensen was considering, right? The two arguments that went up, that got to the per curiam opinion, the categorical approach, the isomer argument. We've got to look at everything she was considering at that point. Does the case turn then on the level of generality between categorical approach and isomer argument, or does it turn on the full picture of what Ms. Christensen was considering?
I think it turns on whether the isomer mismatch argument that counsel concededly missed was clearly stronger than the arguments that she raised on appeal. So this court has said that the way Strickland applies when you're looking at appellate counsel is whether the argument that counsel failed to make was both obvious and clearly stronger than the arguments that were made on appeal. And here, that argument was clearly stronger, even in a plain error posture.
And why was it clearly stronger?
So the argument was clearly stronger because of the categorical approach being well established, and then the mismatch between the statutes being so obvious from the plain text of the statute. And then by comparison, the arguments that counsel did raise were real long shots. So her primary argument that she raised was that the government's proffer was insufficient to establish conspiracy as opposed to a buyer-seller relationship. But that argument was all but foreclosed by circuit precedent, which said that that evidence very similar to what the government proffered would be sufficient to establish conspiracy. And so that's namely where you have wholesale transactions, repeat transactions, and importantly, transactions that were on credit. And that was what the government proffered. And so Mr. Neal had it was a very long shot argument for appellate counsel to make.
It's appellate advocacy is a challenge, right? And there's this sorting function that the appellate lawyer has to do between and among these arguments. Some will be grounded in the record, some won't. Some will be a function of plain error, others won't. Part of what we assume is the appellate counsel is familiar with the case law and knows which is going to be stronger or weaker. That kind of a call we have to take into account things like plain error and things like grounded in the record, right?
Yes, Your Honor. It's true that counsel does have to make these choices, and that also this would be a very different case if appellate counsel had actually recognized the isomer mismatch argument and had made a determination, knowing exactly what the claim was, that it was weaker than the arguments she raised, but that she didn't make that comparison, and so that's an important point to note.
We know she was involved in the Elder case, so we know she's familiar with that type of argument. That's why I'm asking, and I apologize for being repetitive here, if it comes down to level of generality, we've got to look at the full record, right? We can't just say isomer argument versus no isomer argument. Don't we have to look at, compare and contrast all three?
Yes, Your Honor. Right. Yes, that's how this court has approached Strickland challenges to appellate counsel.
Okay.
And so appellate counsel here, the arguments that she raised, they were not clearly stronger than the argument that she missed. And also, it's worth noting that the arguments that she raised were even arguably in the plain error posture, or best case reviewable for abuse of discretion. Now, turning to sentencing counsel, here, this is really a straightforward application of Coleman, because it is clear from sentencing counsel's affidavit that he did not consider the isomer mismatch argument, and also that there was no good reason, unlike in Harris, for him not to have used that argument. Now, the government, they argue that he focused on the challenges to the guideline enhancements, and that ultimately the government offered a agreement under which the government would limit its recommendation of a sentence to no more than 20 years. But that is simply, as we explained in our reply brief, not an equivalent outcome to the outcome he would have achieved if he had challenged the Section 851 enhancement. And moreover, sentencing counsel didn't, unlike in Harris, sentencing counsel did not have to choose between challenging the guideline enhancements and challenging the Section 851. He could have done both, and competent counsel would have done both here. Finally, turning to plea counsel's deficiency in failing to consider the argument may be a reason for setting aside Mr. Neal's guilty plea because of a reasonable probability that the outcome would have been different if counsel had used the argument and had correctly advised Mr. Neal. It would have changed Mr. Neal's calculus in deciding whether to plead guilty or go to trial, particularly as he did not get anything in exchange for his open guilty plea. And also, if plea counsel had recognized this argument and had used it in negotiations with the government, that would have added leverage to Mr. Neal in his plea negotiations. So that's similar to what this court recognized in Brock-Miller.
But can we go back to performance for both plea counsel and sentencing counsel? Okay, you're focusing a little more on prejudice right now. If we look at the timeline of all these cases, it looks like plea counsel would have been one of the very first attorneys in our circuit to raise a Ruth-like argument at the time of his plea, because he's pleading back in 2016.
That's correct.
August 2016. So how are we able to say that an attorney who would be the first, or one of the very first, to raise a particular argument was ineffective for not raising it?
So I think that this court has already said that in Coleman, where the relevant lawyer was operating in 2014, so even 2 years earlier. And there, similarly, although no attorney had raised this challenge, the court still said, because the categorical approach was well established, and because the comparison of the statutes, it's so obvious that the state statute is overbroad, that even in the absence of favorable precedent on point, directly on point on this issue, counsel still, minimally competent counsel would have recognized this argument.
So from your perspective, it's not even a different analysis between all three attorneys, because Coleman governs all three views, all three looks.
I believe, yes, Coleman directly controls plea counsel and sentencing counsel. With appellate counsel, it's slightly different because the court has had this different gloss on Strickland there. But yes, I do believe this court has already was well aware in the Coleman case that this was not an argument that was being routinely made at the time, and nonetheless concluded that it was required for minimally competent counsel. If this court has no further questions, I'd like to reserve the remainder of my time for rebuttal.
Thank you, Ms. Schnorr. Mr. Reed, we'll move to you now for argument on behalf of the government.
Judges, and may it please the court, Peter Reed for the United States. Defense counsel's choices are not judged in the abstract. As Harris and Coleman show, context matters. I'd like to talk about 2 points of legal context as to the appellate counsel claim and 3 points of factual context as to the 2 trial attorneys. So starting with appellate counsel, first, Mr. Neal asks this court for doubly rare relief. There's 2 different standards at play when judging what appellate counsel Ms. Christensen was doing here. The first is the plain error standard, right? This court has said in Ramirez that this court will rarely grant relief on an issue of first impression under a plain error standard. And when Ms. Christensen testified below, she pointed this out. She said, look, I'm not going to raise an issue of first impression under a plain error standard unless I got nothing else, because that's what this court has directed appellate counsel to do. And the second rare circumstance, I think here, is finding ineffective assistance of appellate counsel. As Judge Brendan pointed out, the standard is very high. This court has said that it will only find ineffective assistance of appellate counsel where an argument was obvious and clearly stronger than the arguments that were actually raised by appellate counsel. And here both of these standards are layered, right? Was it obvious to raise an issue of first impression under plain error review? And the answer is no.
Ruth itself was a clear error case, a plain error case, correct?
Judge, Ruth itself was a plain error case, but I'd point to 3 things that the court had in Ruth that Ms. Christensen didn't have when she was considering this claim in 2018. The first is the decision in Elder, right? Brock Miller said that that was an issue of first impression before this court, whether the categorical approach applied to 851. Brock Miller is what she had. She saw it as an issue of first impression, and Ramirez tells her, look, you're not likely to succeed on a claim of first impression under a plain error standard. The second thing
but how does that not cut against you on this point, because she's counsel in Elder and preparing the Elder brief?
Judge, I think that it shows an attorney who's very aware of what's going on in this court, who knows, boy, this is an argument that should be pressed in the right situation, but she didn't see it, she raised it in Elder. Her office raised it in Ruth. But to suggest that all of those things were going to happen in 2018 in one case, this panel has all been in the trenches. In the trenches, you say, okay, is this an argument I want to raise now at this time, given the cards I have to play?
But that's not what she said happened.
Judge, what she said happened is that she looked at the statute.
She didn't finish looking at the statute.
Right. I think what she said is that she looked at the statute, she saw a cocaine match. That was the kind of categorical match that the court had been looking for up to that point. She acknowledges, as you say, that she didn't look through and say, hey, this says this kind of isomer, and the federal statute says this kind of isomer. And I'll add, she went on and said, look, it would have been obvious if I had really understood that the isomers were differently described. And again, this is a context point to come back to what was available in Ruth that might not have been available in 2018, right? Not only do you have Elder, but you have Delatour, where this court had said, hey, look, if we dig into the science and see how these different isomers, whether they line up, that might create a categorical mismatch. And the third thing that the court had in Ruth that Ms. Christensen didn't have in 2018 is the record in Ruth, right? It was a plain error case, but it was an unusual plain error case, in that the argument had been raised under the career offender guideline. And so the scientific facts had actually been briefed out. There was an affidavit in the record to show, hey, here's what a positional isomer is. So I say all that to come back to your question, which is, Ms. Christensen testified, it would have been obvious to me if I had really understood that the isomers were differently described, her words, right? For me, prior to Ruth, I didn't know what a positional isomer was. I think that most people in this courtroom would say the same thing. I think Ms. Christensen was pointing to the same idea, right? There's a factual development and a legal development between when she was looking at this issue in 2018 and when Ruth was decided in 2020, including that factual record in Ruth that allowed the court to say, hey, this is what a positional isomer is. That wasn't available to Ms. Christensen, and she really didn't have the resources or ability to raise that on a cold record under plain error review.
But your analysis here is not what the district court did. The district court didn't have Coleman. Why shouldn't we send this back to the district court to consider all of that?
Judge, I think the court did have Harris, and I think that this case is most similar to Harris, and that's the second legal point that I would like to make, right? So as a legal matter, appellate counsel, it's a very different standard here than on Coleman and Harris. It's much more differential to what appellate counsel was doing, not only because of plain error review, but also because of the obvious standard that this court applies. It must be an obvious argument. So the reason I say it's closer to Coleman than to Harris is this. Coleman says...
Reverse, closer to Harris.
I'm sorry,
than
thank you,
Coleman.
Judge. Thank you very much. The reason this case is closer to Harris than to Coleman is because Harris says over and over again that this argument in 2018, the same time as Christensen was looking at it, was uncertain. Some of the language that the Harris decision uses talks about being risky, it being novel, it being not supported by case law, it being unprecedented, right? All of these adjectives that describe the strength of the argument make it clear that it wasn't obvious when Ms. Christensen was looking at this in 2018. Right?
So same question, Mr. Reed, for you that I had from Ms. Schnorr. Is this turned then on the level of generality?
Judge, I think it can turn on the level of generality, but I think here it more obviously turns on the type of legal standard that Ms. Christensen was dealing with, right? It turns first, and I think principally, on the standard. Is it obvious to raise an issue of first impression under plain error review? And the answer is almost never, right? The reply brief suggests that this shouldn't be dispositive, but opposing counsel points to one case from the 8th Circuit over 25 years ago that granted relief under these circumstances. And even in that case, it wasn't an issue of first impression. Is it obvious to raise an issue of first impression under plain error review? And Judge, I think that it also turns on the level of generality, right? When you look at Bridges and the portion of Bridges that looks at Hinton, Hinton says that strategic choices made after less than a complete investigation. I think that's what we're dealing with. If you have more investigation than you might have had in Coleman, what does that say about the reasonableness of Ms. Christensen's conduct? And I think it certainly errs. It shows that we're closer to Harris than we are to Coleman, right? Ms. Christensen, who knew to look for a categorical approach argument under 851, she looked at the statute. She didn't notice the isomer difference. She said, even if I had noticed it, it would have been obvious, but only if I really understood what that was differently described. As a matter of level of generality, she's gone a lot farther in investigating this issue than the attorney in Coleman or the attorney in Harris, and that's shown by the record. She's at the cutting edge of what the court was doing in Elder. She was the attorney who raised it. And I think that has to go to the reasonableness of her conduct, especially under a heightened standard for appellate review. So with my remaining time, I'd like to turn to the two trial attorneys, plea counsel, and sentencing counsel. And I said I had three facts for context here. The first fact is that Mr. Neal's case has always been about over 5 kilograms of cocaine, right? 5 kilograms is the minimum amount for the statute under B1A, which potentially exposes a defendant to a maximum of a life sentence. However, the government, when the government charged this case back in 2014, the guideline range was under 20 years. So the offense that's charged is B1C with the statutory maximum of 20 years. But there's an important context here that both plea counsel and sentencing counsel were dealing with, which is that the government could have superseded under B1A the moment there was any challenge to the 851 enhancement, right? There are multiple ways the government could have increased the statutory maximum from 20 years. They chose one, but there is another one sitting right there, and the record shows that defense counsel was well aware of that. Second factual point of context is that Neal's post-indictment conduct was what drove his sentence, right? It moved his sentence up 9 offense levels under the guidelines. This was fleeing, carjacking, threatening witnesses in 2016, threatening to get them killed, and losing acceptance at the very end, right? 9 offense levels, that's what drives his sentence up to 30 years, not the drug amount. The drug amount as originally charged, had him under 20 years. And this matters because when you look at what trial counsel did and you look at the whole scope of what they were doing, he started under 20 years. His post-indictment conduct drove his guideline range up. And then plea counsel works to move it back down to where it was. And that's exactly...
And has some success.
Exactly, and with some success. In fact, on the right before sentencing, the government and defense counsel reached an agreed 10 to 20 years recommendation. Again, I know this is a recommendation. It's not a statutory maximum. It's different, but that's what plea counsel is doing. And you got to look at what plea counsel is doing. He's trying to move the case back to where it was as charged before Mr. Neal's post-indictment conduct drove his guideline levels up. Now, what does this have to do with Strickland prejudice, or Strickland reasonableness? Well, first, as to plea counsel, he knows that when he files at 851, or when he challenges at 851, the government can supersede. He said that in his affidavit. I just don't think this is disputed. Mr. Neal himself acknowledged at the plea hearing that the government could prove beyond a reasonable doubt that there was more than 5 kilograms of cocaine involved here. In fact, it was close to 17. Counsel knew this. He had told Mr. Neal this. Everyone knew that there was more than 5 kilograms, and so a statutory maximum of 10 years was certainly in the cards up until the plea.
Mr. Reed, in Harris, the contrasting argument that was being considered is a life imprisonment.
Right.
You know, that's the bird in the hand, two in the bush type metaphor. Here, the contrasting argument is not as harsh. It is the two arguments that ultimately were pressed versus the categorical. The two arguments in the record, not plain error, the one argument plain error, however, present in Ms. Christensen's mind as a result of Elder.
Right.
How do you do the comparison contrast? Similar question that I asked Ms. Schnorr.
Judge, I think that this case, at least as the plea counsel, is very similar to Harris. I recognize, as you say, that the trade-off is not as harsh. But what you did have was a recognition by plea counsel that if what she needed to do was drive the offense, the guideline range down, right? And that if she had challenged the 851 enhancement, the superseding indictment was waiting around the corner, right? So for her, there's a risky argument challenging an 851 enhancement that's risky and uncertain. And again, she didn't consider this, but objectively speaking, an objective counsel in her position, there's a risky argument. And in contrast, she knows as soon as she makes that challenge, she could face a superseding indictment that makes it all a moot point anyway. Not only by driving up the statutory maximum, but potentially stacking the 851 on top of that higher statutory maximum in a way that could increase or could create a statutory minimum. So you have a risky argument with little to gain, at least as to plea counsel, right? And for sentencing counsel, again, I think the focus was sentencing counsel, who was only on the case for 6 or 7 months because of the way Mr. Neal kept firing attorneys over and over again. Plea counsel went out and did what Mr. Neal asked him to do. He interviewed witnesses. He pursued this career offender enhancement argument that Mr. Neal asked him to make. And before, on the verge of sentencing, he had offer in hand, right? 10 to 20 years. Do you want it or do you not? The only problem was that Mr. Neal blew it all up right before sentencing. So as to sentencing counsel, again, I think the trade-off there is a little bit different than it looks like in Harris, but it's the same kind of analysis, right? You have a risky argument that really kind of undermines what his plea counsel was trying to do in the case, right? It's a little bit, because there's so many attorneys, it's hard to jam together, but it undermines what was going on in the case. There's something that looks like a plea agreement here, right? We're going to keep it, we're going to have him plead to what was charged under B1C, and in exchange, we're not going to supersede, right? So when it comes to plea agreement, you also have a trade-off. Do I focus on these enhancements? Do I try to get the guideline range down? Or do I make this risky argument about an 851 enhancement? And I think there we're closer to Harris than we are to Coleman on the record. And I think there's sufficient facts in the record to decide it as it's before the court right now.
Thank you very much, Mr. Reed. Ms. Schnorr, we'll move back to you now for rebuttal argument.
Thank you, Your Honor. So starting with appellate counsel, the government argued that that counsel would have needed to dig into the science to recognize this argument, and that is simply not true. As the court has already recognized in Harris and Coleman, counsel simply needed to look at the plain text of the statute. And here also appellate counsel testified that she had raised many plain error issues, and that was not necessarily a reason not to make the argument here. Next, on sentencing counsel, the government's brief acknowledges at page 42 that sentencing counsel did not have to make a choice between pursuing the guidelines enhancements and pursuing the 851 enhancement here. And government also noted the post-indictment conduct here, and I would submit that that is all the more reason to focus on the Section 851 issue, which would have decreased the statutory maximum that Mr. Neal was facing, and that with the statutory maximum, with the Section 851 enhancement, his sentencing exposure was 50% higher than it would have been otherwise. And so this was an argument that any reasonable counsel would have pursued. Finally, on plea counsel, so the government asserts that the government could have issued a superseding indictment. We think that on this record, it is simply not clear, and an evidentiary hearing is necessary to determine sort of what exactly plea counsel had been told from the government about the possibility of a superseding indictment. And in particular, the government's evidence here was not so strong. There was not, certainly not physical evidence or documentary evidence of more than 5 kilograms. The government was relying on simply the testimony of an officer based on an in-custody interview with Mr. Neal, where there was no transcript, no signed document, and supposedly there would have been a video recording, but it was lost. So for that reason, we believe it is not clear from this record that Mr. Neal would not be entitled to relief on his claim as to plea counsel. If there are no questions, we would ask that the court vacate Mr. Neal's sentence, reverse the district court's denial of his 2255 motion, and remand for further proceedings.
Thank you, Ms. Schnorr. Ms. Schnorr, you're appointed counsel, and you have the great thanks, both you and your firm, the great thanks of our court for having taken on the case. Also, welcome back to the court at which you clerked. I'm sure all the clerks over here on the side admire the argument of both you and Mr. Reed. Excellent advocacy, both written and oral by both sides. Thank you very much.
Thank you, Your Honor.
Case will be taken under advisement. We're going to move now to Appeal 24-1532. This is Farhan versus 2715 NMA LLC et al. And we're going to begin with argument. Counsel, was it Weichel or? Weichel, thank you very much. We'll begin with you. Thank you.
And good morning, Your Honors. May it please the court. My name is Cheryl Weichel. I represent Manal Farhan. The court below made 3 significant errors in dismissing our Fair Housing Act claims. First, the court below took essentially the defendant's version of facts as true. Second, the court below applied a series of precedents based on summary judgment without ever letting us proceed to discovery, and drawing a bunch of factual inferences from the discovery that never happened based on taking defendant's word for what happened. And third, the court ignored the binding precedent of this court in Block v. Frischholz. And I'd like to take those in order, if I may. First of all, we need to address what it is that brought us here, and that is a policy that the defendants created that requires tenants to remain neutral on the issue of the Israeli-Palestinian conflict, and as such, prohibits tenants from putting in their windows Israeli or Palestinian flags. The issue here applies to my client, who is Palestinian. My client's family is from Al-Maha in the West Bank. Her family still lives in and around Ramallah, in the villages near there, and she flies the flag because of her identity. It is who she is. And what the defendants did, and what the court below did, and we believe that it is error, is it turned my client's identity into a political issue. The problem is, once you have any kind of policy, facially neutral or otherwise, that requires someone to be neutral on a political issue, you necessarily undermine their identity. Imagine, for example, a policy that says that a gay couple must remain neutral on the issue of gay marriage, or a policy that says that a queer couple cannot fly a queer pride flag because that the landlord requires that the tenants remain neutral. The issue is that once you go there, you can't unring that bell. When symbols represent people, and that is what this court recognized in Block versus Frischholz.
Did the Fishman Company know, though, the nationality or national origin of Farhan?
They did, though, and this is important because the district court sort of glossed over this a little bit, but before the notice of termination was given to my client, she had that conversation, and we actually alleged this in the complaint. In paragraphs 19 through 31, we actually, in the complaint, go through the conversation that my client had with Vida Sleeman, I apologize, an employee of the defendants, in which Ms. Sleeman stated that it was the policy of the defendants that no one was allowed to put up a Palestinian flag because of their neutrality policy. My client explained that she is Palestinian, and in response, Ms. Sleeman stated that if she continued to have the flag up, she would be evicted.
So the sequence is a call from Fishman to your client indicating the flag should come down. And I think my question focuses on what knowledge Fishman Company would have had about your client's national origin or nationality before the call.
But that's a great question, Your Honor, and here's the problem. That's a question of fact for summary judgment, and we never got there. Because the problem is, the court below took defendant's version of events as we had no idea. But the reason that these cases, that most of the cases cited by both sides for the questions of law here are summary judgment cases is because there's a developed factual record. Intent is a question of fact. Go ahead, Pam. Go ahead, Pam.
And I actually hear you to be saying there are two different knowledge points that could be relevant if you were to engage in discovery. One is the question that Judge Brennan has just asked. What did they know about Ms. Farhan's national origin at the time they made the call saying the flag should come down? Then I hear you to be saying there's a second knowledge point. During the call, the defendants are in fact informed, I am Palestinian. And at that point, they apply the policy to her, regardless of that knowledge.
Correct.
Is that what you are arguing before?
Correct. And that is our point, that intent and knowledge are fact questions. We never got any depositions. The court below never even let us get initial disclosures. Instead, the court said we didn't plead evidence, a word that the court below used and the defendants attempted to explain away. But sometimes the court means what it says. And the court was asking us to plead evidence without discovery and then applying cases that have summary judgment standards. We were entitled at the very least to discovery on the issue of intent. And yes, it is entirely possible, as defendants are saying, well, we would get summary judgment anyway, just like in Hamad. The problem is we're going to win isn't a basis to skip a bunch of steps during litigation.
But at this step, what's the plausible inference? What are you asking the court to hold in regards to the discriminatory intent?
We are asking the court to hold that they knew that she was Palestinian and flying the flag as a result of her heritage from the beginning, and that they applied this policy to her, notwithstanding her Palestinian identity. At the very least, they gave her a notice of termination, knowing that she was Palestinian, knowing that she was putting the flag in her window because of her Palestinian identity, and as a result, that was the sole basis for them terminating her lease. So what we are asking the court to infer, because on a motion to dismiss, all facts alleged in the complaint are true, and all inferences are in favor of the non-moving party, and none of that happened below. And so if the defendant is going to be saying, that isn't what happened, and if the court below is going to say, well, I'm taking the defendant's version of what they knew and when, at the very least, we're entitled to discovery on that issue and develop a factual record. And that is what we are saying should have happened below, especially given the good questions that Your Honors are asking about what the defendants knew and when they knew it, all of which was simply taken based on the defendant's word in the briefing.
And what are you asking us to hold in regards to this policy? That if there's a policy that involves something that does go to someone's identity, such as a flag, if there's a policy on neutrality that violates the FHA, or does there need to be more? Does there need to be a plausible inference regarding intent?
I'm happy to answer Your Honor's question, and then I will reserve the balance of my time for rebuttal. We don't believe that Your Honors even have to hold anything as to the policy, because the application of the policy here goes to intent that we never got a factual record on. It is entirely possible, just like in Block, that a facially neutral policy could be just that, facially neutral. It's also possible that this policy was invented to target my client because they knew she was Palestinian. And as we set forth in the case law, in the Shea case, in the other cases that we cited, at this point in the litigation, we're entitled to those inferences.
Would you like to reserve the remainder of your time?
Thank you very much.
Very good, thank you. Is it Sirlook? Close enough. Very good, okay, thank you, counsel.
May it please the court. Jonathan Sirlock on behalf of the defendants' appellees. The district court correctly dismissed the complaint with prejudice. Under the plausibility standards articulated in Twombly and Iqbal, plaintiff has not alleged any facts showing that she has a plausible claim. She has not alleged facts showing that defendants were taken intentionally because of her national origin. Moreover, plaintiff has alleged facts that have in fact pled herself out of court. In fact, she alleges that there was a neutrality policy, and therefore enforcement of that neutrality policy is inherently discriminatory. And I'll pick up where Your Honors finished her questioning of Ms. Weichel. At most, she showed that there was this the policy prohibited someone of Palestinian origin from flying a Palestinian flag, in spite of her national origin, not because of her national origin. Below, the plaintiffs conceded that this same policy would apply to anybody flying a Palestinian flag, or a Jewish or Israeli person sympathizing with Palestinians flying a Palestinian flag. The issue is with what the issue that they take issue with. Sorry to articulate. The issue that they have is the discrimination, not discrimination, but what the flag represents. And there's nothing wrong with an apartment owner.
Let me skip to a part that would help me. The company says, flags outside the building are against the lease. Certainly looks like it from section 2.2L or whatever the section is. Then in the conversation, Ms. Farhan says, okay, and I'm paraphrasing, I'll put it inside my window, which would not seem to be a violation of the lease. She's told, you can't do that. You can't put a flag inside your window because that wouldn't be neutral. What is your response to Ms. Farhan's argument that what they're alleging is that other tenants are permitted to have religious or other symbols inside, and this is in the complaint, inside their window, but she was told in that conversation she can't have a flag inside her window.
That's not in her allegations. There's no allegation that there was a phone call that said, or a conversation that she could not have it in her window. But putting that aside, as Judge Gettleman correctly noted, there would have to be pled facts about the national origins of those other individuals. We'd have to know if people were treated differently based on their national origin of the people putting up those symbols. And there are no facts at all and alleged regarding that. Plus, if you look at the Block case, which plaintiff relies upon, it actually is supportive of us in that case. In that case, for 3 years, they didn't enforce a policy of taking down, having people taking down mezuzah or crucifixes or other symbols. And then after 3 years, when they were doing a renovation project, they started having people taking those symbols down, including mezuzah and crucifix. And this court, in the Block case, said if that were the only allegation, that would not violate the FHA, that suddenly they now are enforcing a clause in the lease that they previously didn't clause, because it's a neutral clause and it applies equally to everybody. But in the Block case, there was far more. There was facts that were elicited about anti-Semitic animus by the board president against Ms. Block. Those facts are not alleged here. There's nothing to indicate.
I'm looking at paragraph 31 of the complaint. Moreover, Slinian had informed plaintiff that she would not be permitted to have the flag completely inside her window either, because that was not neutral.
Okay.
I'm trying to understand what you're telling me about this paragraph is not in the complaint.
Okay. I apologize, Your Honor. I had forgotten the paragraph 31 because it's after the conversation. But even assuming that conversation's true,
Which we must do at this point.
True. Even that would not be discriminatory based on the FHA, because you're applying that to everybody regardless of their national origin. There's no facts alleged that someone put a Palestinian flag in the window that was allowed to do it and that person wasn't of Palestinian origin. There's no allegations that people put Israeli flags in their windows.
Paragraph 32 then says, her allegation is this is pretextual. Then we go down to 34, that there are other tenants who display Christmas or holiday decorations, Hanukkah menorahs, etc. So there are some allegations here. I take it defendant disagrees, but why not have discovery?
Because those allegations don't support the proposition that a neutrality policy would prohibit the displaying of Christmas or holiday decorations or seasonal art such as snowflakes or Hanukkah menorahs. There's no allegation that anybody displaying that would be favored based on their nationality. It's an apples and oranges thing. You can
Are you assuming the neutrality policy is a thing and it's legitimate, whereas she is alleging that it's pretextual and being used? So to understand from your perspective, do we need to adopt your view of the neutrality policy?
No, in fact, I'm assuming there's a policy. Obviously this is a 12B6 motion, so we're assuming well-pled facts is true. And so let's assume that there was a neutrality policy, that they made this neutrality policy, that tenants should be neutral in the Israeli-Palestinian conflict, that enforcing it on everybody, there's no evidence that they just targeted somebody who was a Palestinian American. If a person who's Anglo-American, Scottish American, Irish American put the Palestinian flag in their window, there could be no argument that asking that person to take it out of their window, either inside or from the out, would not violate the FHA, because you're not acting about the person's national origin. As Judge Gettleman noted, the plaintiff's issue is not the tenant's national origin, it's the tenant's conduct. As they've pled it, they're concerned about the Palestinian flag or the Israeli flag. They're not concerned about the national origin of the person who hangs the flag. And so what at the end of the day, what plaintiff is asking for is what the Supreme Court and this court said you can't have, and that is a national origin accommodation. What plaintiff is looking for is a rule that says where a person is of some certain national origin, you have to ignore a neutral policy or a neutral lease provision and allow that person to fly the flag of their national origin. And respectfully, Your Honor, that's not allowed under our case law. And in fact, if you just take that hypothetical out to the logical extreme, that would prohibit a landlord from taking control of the outside of his building. He would be required to have everybody be allowed to fly their flag of their national origin, and that's not allowed. The case law does not provide for national origin accommodation under the FHA. And that, at the end of the day, is what plaintiff is asking for. again, there would be, if you take these hypotheticals about, things that people might find offensive, and not allow a landlord to address that. I mean, remember, there was a complaint. There was an allegation that there was a complaint made by another tenant. And it's not case law, but in doing the research, there is some guidance from, I think, like a California Department of Housing that says if you fly a Confederate flag, if a landlord allows a Confederate flag or a Nazi flag or some other flag, or a tenant to fly a banner that indicates some type of animus toward a minority, the landlord can be held liable under the FHA for allowing that to happen. So here, assuming that taking the allegations is true, a neutrality policy that applies equally to everyone, regardless of national origin, is allowed under the FHA. And for those reasons, unless the court has further questions, I ask the court affirm the district court.
Thank you, counsel. We'll go back to rebuttal argument.
Thank you, Your Honors. I just want to address very quickly a couple of the points that counsel made. We're not asking for this court to enunciate any rules about neutrality policies. We're asking this court to reverse the lower court and send us back for discovery, because intent is a question of fact. And I think what defendant's argument just disclosed very clearly is how many questions of fact there are here about when the defendant knew that plaintiff was Palestinian, why they put this neutrality policy in place for this particular conflict, which has to do with people of these particular national origins. Now, I do want to emphasize a couple of things. We're not in California. There's no liability that is going to attach, and there's nothing in the record that indicates any liability will attach to the defendant for having a Palestinian flag in a tenant's window. But I will say this, that if they are barring Palestinians from putting Palestinian flags in their windows because those tenants are Palestinian, that does violate the Fair Housing Act. That is the very sort of thing that Block versus Frischholz said you can't do. To put it a different way, there is nothing, a big hand of God won't come down and stop a Christian or a Muslim from putting a mezuzah in their doorway. And so if the condo association in Block made the argument, well, we're not being anti-Semitic, you're saying you can't put a mezuzah in your doorway and it applies to everybody, like the old Anatole France axiom. But what Block had and we don't is the benefit of a developed factual record after discovery. Those facts the defendant's counsel was talking about that were available in Block were on summary judgment after discovery, depositions, and discovery answers, all going to the intent of that facially neutral policy. We have none of that here because Judge Gettleman decided to skip to the end. He believed that in the end, because of Hamad, the defendants would win anyway, but that is not how our system works. So what we're asking for is the discovery that we are entitled to, that we believe we're entitled to under the rules, and I thank you very much for your consideration.
Thank you to both counsel. The case will take under advisement. Our next case is taken on the briefs. So we're going to move to our final case of the morning. This is Appeal 24-1331, Michael Mogan versus Portfolio Media, Inc. And we'll begin with argument from the appellant. Mr. Mogan, you'll go first.
Thank you and good morning, judges.
Good morning.
May it please the court. In my brief, I tried to follow chronologically. I'm going to go a little out of order, at least to the defamation. But first of all, appellees literally filed a motion to dismiss in response to a motion for leave to amend the complaint. In the Seventh Circuit all the time, you issue published opinions and unpublished opinions. So what is now stopping a defendant in a defamation claim citing the district court opinion as precedent, which it can be, and to do the same thing? And from the briefing, this wasn't a simple defamation claim. So is for the motion to dismiss. I honestly asked you just to summarily dismiss it. I wasn't afforded any, type of discovery and what have you. I was surprised by that. I did try to fit a response in the district court. We did have, oral argument, but upon reading the order, it was completely, I don't remember appellee citing any precedent where that's ever been done again. Moving on to there was a question whether Illinois law applies. I think the issue's been fairly well briefed. I live here, I practice law here, I was injured here. I did practice in California at the time, the defendants in New York, but clearly if you're looking at the 3 states, most significant relationship is here, place of injury is here. Again, I live here, and even ignoring what's going to control libel law, that's a different issue. Now I'd like to essentially discuss, there was 2 articles, one that was republished. I attended a hearing remotely in Los Angeles from essentially the plaintiff, an attorney, in an ADA Title II claim. Can you tell that from the article? No. I gave you a copy of the complaint. The face of the complaint says Title II. It says Section 1983, and there's a California Civil Unruh Act. It very mirrors Title II ADA claims. And it's really one of the worst ones you'll ever see. I've included in the reply brief in detail, but it involves them accusing me of not being, it's hard to talk about not being disabled, lying about it, denial of reasonable accommodations, stating that because there's no cure for it, essentially I don't deserve a reasonable accommodation. They also disclose my medical records without my consent. And so you go through this May 8th article, and it says this lawsuit stems from a lawsuit filed in the San Francisco court, which is a civil RICO claim. Can you tell that from the article? No. I mean, it should be common knowledge, the complexity of a civil RICO claim. It then goes on to say, it references a September 2019 San Francisco interlocutor order where a judge made statements, I don't want to misstate the allegations, but that I compounded my misconduct by accusing opposing counsel of committing fraud on the court, which a judge found baseless and unprofessional. California Appellate Court already reviewed that, and they did mislead the court and was fraud on the court, so it wasn't unprofessional. This May 8, 2023 article, it wasn't written in September 2019. It was essentially written in May 2023. So how is that a fair abridgment of the proceedings? It again casts me as being unprofessional, and that's kind of the basis of what defamation is. And there's another allegation saying that I tried to take advantage of a clerical error by the American Arbitration Association to avoid a court's order to arbitrate a dispute. And so again, there was no clerical error. The opposing counsel misled the judge. And so that's clearly defamation. There's no, I think me just explaining what happened here, if it was a fair abridgment of the official proceedings, you should be able to tell that at least in summary form. And so with Law 360, contrary to the name Law 360, if they see the word sanction, fine, attorney fees, Airbnb, that's all they're really concerned with in essentially tagging another article. Instead of, I understand that blogs are titled the First Amendment protections, but they also have to act like reporters and not defame people such as myself. The other article essentially makes reference to a proceeding in San Francisco court. This is a little, I think in the record you could tell this, but again, it was a civil RICO case. You can see it was dismissed. And if you read that article, you can't really tell what the gist of the complaint was. I did include a complaint in the record, but essentially I had sued Airbnb for serving me a sanctions motion that they actually never filed. They even asked the court to impose the fees on me. Also, a demand letter, which is sent for no other reason than to intimidate me from seeking relief in a court, which is a civil matter, and multiple, acts of wire fraud, mail fraud, etc. And again, you have Law 360, more concerned with tagging the word Airbnb sanctions. It's unfortunate that, whether it's a small small solo practitioner, lawyer, Airbnb, you're essentially being treated differently. And just going to allegations for the defamation, the appellee is required to prove that it's a fair abridgment of official proceedings. They can't omit facts. It says they tried to accuse Airbnb of fraud, harassment, and extortion. After this company successfully moved for sanctions against me for attempting to reopen my client's case after it was dealt with in arbitration. I don't want to misspeak. Airbnb wasn't a party to any proceedings in San Francisco State Court. So again, you got them tagging Airbnb in an article, putting Airbnb in an article because it's a multi-billion-dollar company at the expense of my reputation. There's another allegation saying one of my client's cases went to arbitration. Airbnb paid its arbitration fee, which again wasn't a party, so that's false. And the transaction was not recorded, which I've already addressed. I alleged that the statement was false, that I filed a cause of action that claimed that I tried to have sanctions lifted. That cast doubt on me as if I'm essentially incompetent attorney. There's nowhere in the record I tried to get anything, lifted. There's actually there's a Chapter 11 proceeding in this building actually that stemmed from everything in here. And so with that, I just like to close. And again, I wasn't afforded any type of discovery. This isn't a single, one allegation of defamation. Perhaps if the district court had just considered their motion to dismiss, within the same proceeding, and the court can't sui sponte dismiss actions, which they do sometimes. But it just was, inappropriate here, and I'd like to reserve the rest of the time for rebuttal. Thank you.
Thank you, Mr. Mogan. We'll now move Ms. McNamara to you.
May it please the court, Elizabeth McNamara on behalf of the Appley Portfolio Media, Inc. Appellant, as you heard this morning, makes the same error before this court that he made below, which is that he fails to explain how or even whether Portfolio Media misrepresented the official proceedings that are the subject of the articles. The record establishes that each of the articles and each of the 13 challenge statements were either direct quotes from the judicial opinions or fair characterizations of them. And as such, they are squarely protected by the fair report privilege. The court reached back and considered the first article in January of 22, as well as the two subsequent articles, and considered carefully each of the 13 statements. It's important to give a little context as to what these decisions were dealing with. The first article, and I very briefly will just note, was an award of sanctions against the appellant as a result of a frivolous motion to lift an arbitration stay and conduct that the court found to be baseless and unprofessional. The next was a federal court ruling that appellant's subsequent action for abusive process and racketeering and the like was also frivolous, and that it was commenced for an improper purpose, thereby later awarding over $162,000 in attorney's fees. It bears noting, while it wasn't a subject of one of the Law 360 articles preceding this federal court action, the appellant also sued the state court judge as well as the appellate court judge for constitutional violations. That too was dismissed. And finally, the third article reported on a hearing on an action appellate commenced against the State Bar of California days after it filed a notice of disciplinary charges because the appellant had failed to pay the sanctions in the state court action. Each of these Law 360 articles were straightforward reports of these judicial proceedings. An appellant never identifies how Law 360 got anything wrong, or critically wrong in a material sense that would be defamatory to him. At most, as you heard this morning, he tries to argue that the findings or facts in the rulings were somehow in error. but this misconstrues a foundational principle of the fair report privilege. It protects the substantial accuracy of the summary of the judicial proceedings. That is the benchmark by which it is judged, not whether the government got it right, whether the decision was right, whether the facts were ultimately true or false. It's whether it was an accurate summary. And there's no dispute in this record and the clear, just straightforward comparison of the articles with the rulings that these were accurate summaries of the rulings. Indeed, you heard again this morning, he contends that the appellate court in California got it wrong because he had proven to that court that the opposing parties intentionally misled the state court about the record. But as the court below found, and as the judicial proceedings clearly established, the California Court of Appeals affirmed that ruling and found no reason to reverse the order, finding that plaintiff's motion was factually and legally frivolous. In short, the appellate does not identify any material error in Law 360's reportings on the judicial proceedings at issue and only continues to attack the underlying merits. For all these reasons, Your Honor, we ask that the court affirm the judgment below, the decision below on this record, as well as everything else before the court. Happy to address any questions.
Thank you, Ms. McNamara.
Thank
Mr.
you very
Mogan, we'll go
much.
back to you now for rebuttal.
Okay, thank you, Judge. If you'll just notice what just happened here, I went line by line telling you what was alleged and what was false, and that didn't occur because there's no defense. I heard that I was sanctioned in federal court for $160,000. The magistrate judge overruled long-standing precedent saying that the litigation privilege bars RICO claims. Opposing counsel misled the court, went up the chain. They abandoned that, and then they said issue preclusion without doing what you just doing here today, give me an oral argument. So again, you got Erin McNews lawyers coming in front of the court. She next says, I sued, I don't want to misspeak her, she said I sued the two judges. So when you have a 1983 claim, you essentially name the judges as defendants, and you're really suing the state of California. So there's a law in California, 1281.98 of the California Civil Procedure, that says you don't pay your arbitration fees on time, you go back to the state court, and essentially you can get a default, attorney fees and everything. I proved that they were late. It was in the process of being passed and acted. The appellate court wouldn't follow that. Wasn't frivolous. Essentially, they said the payment is late. They didn't apply it. So 1983 allows you to file a declaratory relief complaint, not in for any type of damages. And so opposing counsel is even highlighting, the falsity. And can you tell that from the article? No. She next says the California Bar filed charges. That happened in February 2023. I'm glad to say it forcibly made them drop it. Their conduct's got a lot worse, actually, but during a Chapter 11 proceeding for a debt payable to a third party, which can be held in contempt of court, in April of 2024, Ninth Circuit said that's sanctionable conduct. So the California Bar trying to sanction me, which can be held in contempt of court, and as soon as I'm done with the motion, I'll raise it. Completely irrelevant here, but again, it just shows to highlight the falsity in the false statements that are published in the articles. With that, thank you, judges.
Thank you, counsel. The case will be taken under advisement, and that'll complete our hearings for the morning.